Hi, folks. I wanted to talk about the attack that is going on of lawyers, law firms, and judges. That is all of a piece, and it really needs to be viewed together, because what is going on is undermining the ability of lawyers and law firms to, in good faith, bring litigation against the actions of the administration, which of course is what the law allows. It's what the legal system is for, as long as you're doing that in good faith. That's the standard. That's fairly low. And here, without being able to vouch for every single litigation, clearly where the courts are siding with the government, that doesn't mean that the plaintiffs bringing the case have acted in bad faith. And certainly where the courts are siding with the plaintiffs who are suing, it clearly means that it was brought in the good faith standard, which is very low. In other words, the standard is it a meritorious case? There are all sorts of cases that are brought in good faith, and sometimes you win and sometimes you lose. So that's one set of things, attacks on lawyers and law firms. The other is an ongoing attack on the judges, and that is to essentially, once again, it's sort of a brushback pitch to the legal system in terms of think twice before you rule against us. And that's leaving aside the fact that judges who do that are subject to threats by errant people who think that judges are, to use Pam Bondi's phrase, quote, siding or supporting the terrorists by siding with plaintiffs in a case. So let me just talk about what's going on. So there have been so far 3 executive orders. I think I and many other people expect that there will be more against 3 very reputable law firms. Started with Covington Burling, second Perkins Coie, and third Paul Weiss. The Covington executive order was because they had the temerity to represent Jack Smith, which is part of our tradition, is people represent both favorable and unfavorable people, certainly in the defense side. That happens all the time, that you have the noble profession of being defense counsel for people who are worthy and some people who are sort of, you might think are deplorable, who are alleged to have done something bad, but they're entitled to a defense. So here, there's nothing wrong with representing Jack Smith, even if you thought he had done something wrong. I don't think he has, but there's nothing wrong with that whatsoever, and so you shouldn't be subjected to opprobrium and certainly a presidential executive order because you do that. Covington responded by basically saying it's our privilege to represent Jack Smith. That's a paraphrase of what they did. Second was Perkins Coie, and there was a number of things that were alleged in the executive order, but essentially saying it's an executive, it's a firm that represents democratic institutions, Hillary Clinton. There were allegations about one of its former partners, and Perkins Coie brought a lawsuit that was brought in the DC federal court before Beryl Howell, judge there. And she struck down all of the provisions that were challenged in the executive order and found them to be violative of the First Amendment. In other words, it was found to be unconstitutional. And that's sort of where things stood. And then there was another executive order, even in the face of her ruling, against Paul Weiss, again attacking it for the conduct of a former partner, similar to what had happened with Perkins Coie. And one of the things it did is it pulled their security clearances, it subjected them to heightened scrutiny in representing and having access to government buildings. And basically, as the firm said, made it clear that they were a disfavored firm and on the wrong side of Donald Trump. And many of us thought that they would just go to court and they would do exactly what Perkins Coie did, which is they would challenge it, and they had really good precedent from the decision by Beryl Howell that this was something that was unconstitutional. It should be noted that that President, as is his right, the Justice Department had appealed Beryl Howell's decision, and that's pending. There's no decision on that. They're entitled to do that, and we'll see what happens there. I think her decision is amply supported, but we'll see what happens on appeal. So there's nothing wrong with issuing another executive order, and even though there had been this ruling by Beryl Howell, although I would say that in my experience, what you normally would do is hold off doing anything until you could get a ruling from the D.C. Circuit reversing Beryl Howell's decision, rather than subject yet another firm to opprobrium, because it may be that what you're doing is going to be found by that circuit court to still be unconstitutional. So I think the better course certainly would have been to wait. I think if they'd been acting in what I say is a sort of proper good faith fashion, I think that's what they should have done. But that's not what they did. So there was this order, the executive order with respect to Paul Weiss, and there was no litigation. There are a lot of reports in the newspapers speculating about why, and fissures within Paul Weiss, with the corporate department allegedly being very much against that because they were concerned about the effect on the business of Paul Weiss if they were to have brought a lawsuit, and that they would lose clients. I should note that could be argued the other way, which is that their clients, I think that in light of what Paul Weiss did, may leave Paul Weiss. It will remain to be seen what happens. But essentially what happened is, by all accounts, Paul Weiss caved. They didn't go to court, and they had ample reason to go to court to have the order struck down in the same way Perkins Coie did. Instead, we don't know exactly what the agreement is. We only have reports in newspapers about what the agreement is, but here are two components. One, there is an agreement that Paul Weiss will spend $40 million on pro bono work for items and causes that are consistent with those of the Trump administration. That's a big deal. A law firm decides what pro bono work it wants to do and doesn't do. It's a private actor. It can decide to do all of its pro bono work for the Republican Party. It can decide to do all its pro bono work for sort of right to life or right to choose, either one. They're private law firms. They can, and often they do, take on pro bono work that represents the values of the firm. And so the idea that in the face of an executive order that they had ample reason to think was unconstitutional, instead of litigating it, they have quote unquote settled the case by giving $40 million of work to something that they clearly wouldn't normally have done. It doesn't seem to me they would. It remains to be seen how that work, the pro bono work, is actually selected, but the appearance is terrible that this is the executive branch weighing in on and coercing the private sector to do something that it's not required to do. And very consistent, by the way, with the position that the far right took when it was the Biden administration, and what the Biden administration was allowed to do or not allowed to do with respect to the private sector. But this is basically saying we're allowed to coerce them to do that. The second is provision, is that there's a provision that Paul Weiss will engage an audit team to audit its employment and hiring practices. And that raises a lot of concerns about so-called DEI, which is such a funny thing. I mean, it's used as an epithet, but it's about diversity, equity, and inclusion. And Paul Weiss has a long history of believing that there should be diversity at its firm, and they have lived that. There are people there who are not just sort of white men, who are extremely capable lawyers and people, and again, the message is that the firm may no longer be committed to those founding principles, and as long as Paul Weiss is not discriminating illegally against anyone, it can decide who it wants to hire and who it doesn't want to hire. The statement that they appear to have signed off on, which is that they won't base hiring on political affiliation, is one that they may agree with, but it's certainly not required. This is a private entity. They can decide to take on political causes, big P or little p, and as long as they're not discriminating, the government has no say in who they're hiring and what they should be doing. I mean, that's supposedly sort of traditional Republican orthodoxy of the problem of big government. So this is really looks a lot more authoritarian than sort of Republican orthodoxy. There is some dispute between the head of Paul Weiss and the Trump administration as to exactly what was agreed to and what wasn't, and whether the statements about DEI and whether the firm is going to be rolling that back or not is one that appears to be in dispute. No one's seen the written agreement, or I should say no one, the public hasn't seen the written agreement, so we don't know for sure. But the moral of the story, the thing that sent shockwaves and certainly surprised me, is that for a firm as reputable and large and well-respected as Paul Weiss, with wonderful, wonderful attorneys at the firm, people did not expect this kind of caving in the face of an executive order that had already been found, an exact duplicate of this order with respect to Perkins Coie had already been found to be unconstitutional. So the idea of trying to need to settle when this was something that would easily, I think, have been defeated in court suggests a sort of obeying in advance and the power of the dollar and the loss of business as opposed to the adherence to principle. And I think it's Ben Franklin who said we all need to hang together, or we're certainly going to hang separately, in connection with the American war with Britain. This is one where people were looking for Paul Weiss and the firms to be hanging together, and that is certainly not what has happened. And so you're seeing some of the upshot of that, which is I think you're going to see more executive orders with respect to law firms, and it will be interesting to see what route they take. But there's been another executive order in addition to an attack on individual lawyers, including lawyers who are busy suing the administration. There was just, I think this morning, if not last night, an executive order saying that the White House and the President is tasking all agencies, including the Department of Justice, to make sure they enforce the sanctions that can be brought against plaintiffs and plaintiffs' counsel for bringing litigation that is frivolous or unreasonable. And essentially that is, before you sue the administration, the message is you should know the Attorney General of the United States and agencies are going to view that and put you sort of essentially on another kind of enemies list. That's not how it reads. You could read it literally to be, we want to make sure that there's vexatious litigation, that there are sanctions for it, and that's fair. I mean, there shouldn't be vexatious litigation, but what is viewed as vexatious is a little bit in the eye of the beholder, and that is one that the courts determine, ultimately not Pam Bondi or the President of the United States. And it's important for there to be this kind of litigation. It's very hard to view that executive order as anything but sort of dressed up threat to people to think twice before they bring this lawsuit, because you're going to not only have to litigate the lawsuit, but you're going to have to litigate your behavior, and you're going to, people always should stay within good faith, but they have to be extra careful because that everything they do is going to be fly-specked. So clearly will have a deterrent value, and I think many people, including me, think that's the intent behind it. And so that's sort of a second piece, which is to have law firms being sort of subjected to scrutiny and knowing that if they bring and stand behind people, they could be subjected to scrutiny. You have lawyers being told their conduct is going to be fly-specked. Again, if there's discrimination, if there is bad faith, fair game. But again, you have to be really, that's a very small percentage. That's not like a huge problem out there. And you don't see the same kind of executive orders being issued with respect to all sorts of other type of litigation. For instance, what about when the government itself is making bad faith arguments, and the courts have actually pointed out that there are representations have been made, particularly with respect to Doge and who runs it, that seem to fly in the face of the Rule 11 issue of good faith, because they're denying Elon Musk, is actually running Doge when publicly the administration is saying that he is. So with that kind of discrepancy, it's hard to view this as anything other than a ruse to make sure that they are dampening the ability of lawyers to do their job and to challenge administration actions. And then the final thing is really trying to get at the judges. I'm not the first, and I will not be the last to point out that there have been efforts to support the impeachment of judges merely because they are ruling against the government. That's obviously not an impeachable impeachable offense. You have Chief Justice Roberts who weighed in on that. That is certainly a signal about how serious he views the problem, that he chose this moment to do that. There's a judge in the Southern District, Paul Engelmeyer, who is facing those threats. There's Judge Boasberg, who is ruling on the Alien Enemies Act, who's facing these threats. You have Pam Bondi amplifying that by saying that his rulings end up supporting terrorists, which is not at all what he is doing. Just because you find the government doesn't appear to be appropriately relying on the Alien Enemies Act from the late 18th century doesn't mean that you're supporting the people who you're trying to deport. And so that is really kind of shocking language to hear from the Attorney General, because it's really an attack on our judiciary. On the one hand, there's this effort to say they should be impeached, and the other is that there are these very unusual motions to get the judges who are ruling against them removed from the case. If you notice, this is one where let me just contrast that. You have the government moving to say that Judge Boasberg shouldn't be on the case. They've asked the D.C. Circuit to remove him. They have recently filed a motion to have Beryl Howell, the judge who ruled against the government in the Perkins Coie case, to have her removed, saying that she is biased. They don't point out that she just recently denied a temporary restraining order and preliminary injunction, I believe, when plaintiffs were suing the Trump administration on an event. She said, nope, I don't find there's enough here, so that's a counterpoint. But I would contrast this idea of moving to recuse these judges with Jack Smith never, in spite of many people thinking he should, never moved to recuse Judge Cannon, meaning it's a very high standard. You don't get to just say, I don't like the judge's rulings, or that, I think she's being unfair, or I think she could be more even-handed, or I don't think she's, smart enough, or whatever your complaints are. You don't get to sort of change the referee because you don't like the rulings. It's and it should be a very high standard to remove a judge for bias, and it has to be sort of bias outside of the courtroom, typically. And here it's notable to contrast that Jack Smith, who is vilified up one side and down the other by the administration, never did that with respect to Judge Cannon. And yet you have the administration really having an no holds barred, approach with respect to this other tactic of attacking judges by seeking impeachment and seeking removal. I should say, with respect to the impeachment, Elon Musk is putting his money where his mouth is and saying he will support people in Congress who are pro-impeachment. And you can see the insidious way in which money if infects and affects our democratic processes. And then finally, of course, there is a sort of a use of the bully pulpit to attack these judges and to try and make them seem partisan, and to try and say just because they're ruling against the administration that they somehow are supporting terrorism. I've talked about that with respect to Pam Bondi, and I'm not going to repeat that all over again, but I have a Substack post on that particular issue, which meant so much to me, given my history both at the Department of Justice for over 20 years, but also as a defense lawyer for over 10 years, because I think it's a principle that defense lawyers and prosecutors cherish. And just to give one quick analogy, in a normal criminal trial, judges are making rulings all the time, and sometimes it's for the government, sometimes for the defense, but I have never, ever thought when I'm the government that if the ruling went against me, it's because the judge was in favor of the alleged crime that the defendant committed. It was because the judge thought it wasn't either within the rules or appropriate or fair in that situation. But it's not a vote on what the defendant did or did not do, and it's just so outlandish for people who know better to be taking that stance. So that is the attack on the legal system, on the people who can represent people, the people who can go to court and bring these cases, and on the judges who are deciding them. What can we do? One, obviously, lawyers and law firms need to stand together. They need to continue taking these cases and adhering to the rule of law. Judges have lifetime tenure, but I want to make it clear it's really important for people to speak out and support them. It is useful for judges to know that the public is supporting them, that they have their back. It is useful for people who have business. They can vote essentially with their business. In other words, people who are clients who see what's going on are free to bring new cases, and have the work done by law firms that are willing to be independent and stand up and adhere to the best values of the legal profession. And so there are all sorts of ways that people can take action to counteract what is going on, to the extent that you think it's a problem the way I do. Anyway, I wanted to apologize for also not having posted in the last couple days. I have another Substack, a shorter one, about Innes, my dog, who's still doing really well, but explaining why it's been a while. But I'm glad I can spend this time with you on the weekend talking about a very, very serious problem. So stay tuned for more. This is clearly a continuing story with different aspects. So take care, stay safe, stay engaged. Thanks so much for listening. You can subscribe to my YouTube channel up here. And if you want more, which is both video and written material, you can subscribe for free or paid to my Substack channel over here. Thanks so much.